The judge thought it would be harmless, just a quick round of truth or lie with the royal guard. What he didn't expect: the guard had a razor-sharp mind and a legal IQ that could rival any courtroom veteran. Curious how it all played out? Before we break it down, make sure to hit that subscribe button and drop a comment telling us where in the world you're watching from. Now, let's dive in. The morning mist clung to the ancient stones of the Old Bailey like secrets waiting to be told. Inside Courtroom 12, Judge Marcus Wethbone adjusted his robes with the practiced air of a man who had presided over justice for 37 years. His eyes, sharp behind wire-rimmed spectacles, surveyed his domain with satisfaction. Today would be different, though he didn't know it yet. Standing at rigid attention near the witness box was Lieutenant Trevor Millcross of the Queen's Guard, his scarlet tunic immaculate, his bearskin hat casting a shadow over eyes that revealed nothing. The ceremonial sword at his side caught the morning light streaming through the tall windows. To Judge Wethbone, he appeared exactly what he was supposed to be, a decorative soldier, all pomp and no substance. The case that brought them together was routine, a minor dispute over ceremonial protocols that required military testimony. But as they waited for the tardy barrister to arrive, Judge Wethbone's notorious impatience bubbled to the surface. He had built a reputation not just for his legal acumen, but for his sharp wit and tendency to toy with those he deemed intellectually inferior. "Lieutenant Millcross, isn't it?" The judge's voice carried across the courtroom with the casual authority of decades on the bench. "Tell me, in your military service, do you find yourself intellectually stimulated?" The question hung in the air like smoke. Millcross remained motionless, his gaze fixed straight ahead, but those who knew what to look for might have noticed the slightest tightening around his eyes. Judge Wethbone leaned back in his chair, fingers steepled, clearly enjoying himself. "Ask because we have some time to kill, and I find myself curious about the intellectual capacity of our ceremonial forces." The judge's tone was honeyed poison. "Perhaps we could play a little game, something to pass the time. I call it truth or lie." The court reporter's fingers paused over her stenotype machine. The few spectators in the gallery leaned forward slightly. Even the clerk looked up from his papers. "The rules are simple," Wethbone continued, his voice gaining theatrical flair. "I'll state what I claim to be a legal principle or fact. You tell me whether it's truth or lie. Think of it as ... continuing education for our military friends." "What?" Judge Wethbone couldn't see were the memories flickering behind Millcross's composed exterior. Oxford, 1998, a young Trevor Millcross, barely 18, sitting in Professor Hartwell's jurisprudence seminar, dissecting the philosophical foundations of law while his peers struggled with basic concepts. The same mind that had devoured black commentaries during summer holidays while other teenagers played football. "Shall we begin?" Judge Wethbone rubbed his hands together with obvious relish. "Here's an easy one for our decorated soldier. Under English common law, a verbal contract isn't legally binding without at least two witnesses present. Truth or lie?" The judge sat back, confident in his trap. It was a trick question, designed to catch the unwary. Most people would instinctively say truth, because it sounded reasonable, authoritative. But it was false. Verbal contracts could indeed be binding under certain circumstances, though proving them was another matter entirely. Lieutenant Millcross shifted almost imperceptibly. When he spoke, his voice was crisp, clear, and utterly without emotion. "Lie, Your Honor." Judge Wethbone's eyebrows rose slightly. "Lucky guess, perhaps. Care to elaborate?" The judge pressed, his tone suggesting he expected fumbling uncertainty. "Verbal contracts are generally enforceable in English law, Your Honor. The presence of witnesses aids in proving the existence and terms of such contracts, but is not a requirement for validity. The case of Parker v. Clark in 1960 established that even informal family arrangements can constitute binding contracts when there's clear intention to create legal relations." The silence that followed was deafening. Judge Wethbone's confident smile flickered like a candle in the wind. The prosecutor, who had been casually reviewing his notes, looked up sharply. Even the court security officer glanced over with newfound interest. Judge Wethbone cleared his throat, his Game-Master confidence slightly shaken but his competitive nature now fully engaged. "Impressive, Lieutenant. Perhaps that was too elementary. Let's try something more ... substantial." He leaned forward, his voice taking on the cadence of a professor addressing a promising but presumptuous student. In criminal law, the prosecution must establish both actus reus and mens rea beyond reasonable doubt in all criminal offenses, truth or lie. This was more sophisticated bait. The statement was largely true, but contained a crucial exception that would trip up most non-law. Judge Withbone had used this very question to humble cocky law students during his brief academic career, decades earlier. Millcross's response came without hesitation. Lie, Your Honor. While the prosecution must generally prove both the guilty act and guilty mind beyond reasonable doubt, strict liability offenses require only proof of the actus reus. Mens rea is not required for offenses such as regulatory violations. The House of Lords clarified this principle in Sweet v. Parsley in 1970, though the decision was somewhat controversial in its application to drug-related offenses. Judge Withbone's pen snapped in his grip. The prosecutor had now abandoned all pretense of reviewing his case files and was staring openly at the guardsman. A murmur rippled through the small gallery of court watchers who had begun to sense something extraordinary unfolding. Furthermore, Millcross continued in the same measured tone. The Gammon v. Attorney General of Hong Kong case in 1985 established a presumption that statutory offences require mens rea unless Parliament clearly intended otherwise, particularly where the offence carries serious penalties or social stigma. What had begun as judicial sport was rapidly transforming into something altogether different. Judge Withbone found himself in the unfamiliar position of being intellectually challenged in his own courtroom by a man who, by all appearances, should have been discussing drill formations and polishing protocols. "Let's delve deeper into constitutional law," the judge said, his voice now carrying an edge of genuine curiosity mixed with wounded pride. "The royal prerogative powers are entirely discretionary and cannot be subject to judicial review. Truth or lie?" The question was fiendishly complex, touching on some of the most nuanced areas of British constitutional law. Judge Withbone had spent considerable time researching this very issue for a landmark case 5 years earlier. Millcross remained at attention, but something in his posture suggested the intellectual equivalent of a chess master recognizing a worthy opponent. "Lie, Your Honor, though the matter is more complex than a simple true or false would suggest." "Oh." Judge Withbone leaned forward despite himself. While prerogative powers were historically unreviewable, the landscape changed significantly following Council of Civil Service Unions v. Minister for the Civil Service in 1985, the GCHQ case. The House of Lords established that prerogative powers are subject to judicial review, though the courts will not review the exercise of certain prerogatives on grounds of justiciability. The more recent case of R.V., Secretary of State for the Home Department, Ex parte Fire Brigades Union in 1995, further clarified that courts can review the existence and extent of prerogative powers, even if they cannot review their exercise in all circumstances. The courtroom had taken on an almost surreal quality. What should have been a routine morning of legal proceedings had transformed into an impromptu seminar on advanced jurisprudence, led by a man whose job description involved standing very still and looking ceremonial. Judge Withbone removed his spectacles and cleaned them slowly, a gesture that anyone who knew him would recognize as a sign of deep thought. When he replaced them, his expression had shifted from patronizing amusement to something approaching respect. "You seem remarkably well-versed in legal precedent for a guardsman," he observed carefully. "I read, Your Honor," Millcross replied with understated simplicity that somehow made the words more profound than any boast. "What do you read?" "Law reports, Hansard, academic journals when time permits." The prosecutor finally found his voice. "Your Honor, if I may, this is quite extraordinary." But Judge Withbone was no longer playing games. His judicial instincts, honed by decades of evaluating witnesses and assessing character, were fully engaged. "Let's try something from equity and trusts," he said quietly. The 3 certainties required for a valid express trust were established in Knight v. Knight. However, a charitable trust requires only 2 of these certainties: truth or lie. Millcross paused for the first time, not from uncertainty, but from what appeared to be careful consideration of how to frame his response. "The question requires clarification, Your Honor." Knight v. Knight indeed established the 3 certainties: certainty of intention, certainty of subject matter, and certainty of objects. However, your statement about charitable trusts is oversimplified. He paused, and for a moment the formal military bearing gave way to something else, the quiet confidence of a scholar in his element. Charitable trusts must satisfy the certainty of intention and certainty of subject matter. Yes, however, rather than requiring certainty of objects in the traditional sense, they must satisfy the charitable purposes test established in Pemsl's case and refined in subsequent legislation. The test is different, not absent. Moreover, following McPhail v. Dalton in 1971, even non-charitable discretionary trusts need only meet the given postulant test rather than the complete list test for certainty of objects. Judge Worthbone set down his pen entirely. The prosecution table had gone silent. Even the court reporter seemed to be listening more intently than typing. The Charities Act 2011 further codified the requirements. Millcross continued, establishing 13 specific charitable purposes while maintaining the public benefit requirement derived from earlier case law. So while the structure of requirements differs for charitable trusts, it would be incorrect to say they require only two certainties. They require different certainties. Judge Worthbone studied the guardsman with new eyes. The rigid military posture remained unchanged, but something fundamental had shifted in the judge's perception. This was no mere soldier with a hobby interest in law books. Lieutenant Millcross, he said slowly, forgive my curiosity, but your knowledge of legal precedent is quite remarkable. Might I ask about your educational background? For the first time, Millcross's gaze shifted slightly, meeting the judge's eyes directly. I was fortunate to receive a Rhodes Scholarship to Oxford, Your Honor. Magdalen College, reading jurisprudence. The words fell into the courtroom like stones into still water. A Rhodes Scholar, Oxford, reading jurisprudence, not just law, but the philosophy and theory underlying legal systems. First-class honors, I presume. Judge Worthbone's voice had lost all trace of its earlier condescension. Yes, Your Honor, and yet you chose military service. I chose to serve. Your Honor, the nature of that service seemed less important than the commitment to it. The prosecutor, unable to contain himself any longer, leaned forward. Your Honor, if I might ask, what was your thesis topic? Millcross hesitated for just a moment. The intersection of military law and civilian jurisprudence in constitutional democracies, with particular attention to the role of military personnel in upholding legal principles they may be called upon to enforce. A clerk hurried forward with a file that had been hastily retrieved from somewhere in the court's administrative depths. Judge Worthbone accepted it with trembling fingers and began to read. His eyebrows climbed steadily higher as he progressed through the pages. Good Lord, he murmured, then looked up at Millcross with something approaching awe. Lieutenant, according to this file, you graduated summa cum laude from Sandhurst, served with distinction in 3 overseas deployments, hold advanced degrees in both law and military science, and, he paused, squinting at the document. You've been consulted by Parliament on amendments to the Armed Forces Act. When asked, Your Honor, when asked, Judge Worthbone repeated faintly, and you're currently serving as a ceremonial guard because that is where I was assigned. Your Honor, every role in service has its purpose and dignity. The judge set down the file and removed his spectacles again, this time to rub his eyes. When he looked up, his expression had completely transformed from the earlier smugness to something resembling chagrin mixed with genuine admiration. Lieutenant Millcross, I owe you an apology. I began this morning, exercise ... with assumptions that were both unfair and incorrect. No apology necessary, Your Honor. Appearances can be deceiving, and it's natural to make initial judgments based on available information. The tardy barrister finally burst through the courtroom doors, briefcase in hand, and apologies spilling from his lips, only to stop short at the scene before him. Judge Worthbone sat in contemplative silence. The prosecutor stared openly at a guardsman who had just delivered an impromptu masterclass in British law, and the entire courtroom seemed suspended in a moment of quiet revelation. Your Honor, the barrister began uncertainly, I apologize for the delay, but I am ready to proceed with the ceremonial protocols case. Judge Worthbone held up a hand. Actually, Mr. Pemberton, I believe we may be able to expedite matters considerably. He turned to Millcross. Lieutenant, given your evident expertise in both military and civilian law, would you be willing to provide expert testimony on the legal foundations of ceremonial military protocols, if it would assist the court, Your Honor? What followed? was the most efficient and comprehensive resolution of a military protocols dispute in the Old Bailey's recent history. Millcross's testimony was precise, authoritative, and demonstrated an understanding of legal precedent that impressed even the most experienced court officials present. As the session concluded and the courtroom began to empty, Judge Wuthbone remained seated, watching as Lieutenant Millcross resumed his position with the same rigid bearing he had maintained throughout the morning. The next day's Legal Times carried a small headline: "Guardsman provides expert legal testimony at Old Bailey." But those who were present that morning knew they had witnessed something more significant, reminder that wisdom and intelligence often come in unexpected packages, and that the measure of a person's worth cannot be taken from their uniform alone. Judge Wuthbone never again played truth or lie with court participants. Instead, he found himself approaching each new case with a heightened awareness that every person who entered his courtroom might possess depths of knowledge and experience that weren't immediately apparent. Lieutenant Trevor Millcross returned to his duties, standing guard with the same unwavering attention and dignity he had always shown. But now, those few who knew his story understood that his stillness was not emptiness but fullness, the quiet confidence of someone who had nothing to prove because he had already proven everything that mattered. In the weeks that followed, word spread quietly through legal circles about the guardsman who could cite precedent like poetry and explain constitutional law with the precision of a master craftsman. Some tried to recruit him for prestigious law firms, others suggested academic positions. All were politely declined, because Lieutenant Trevor Millcross had learned something that many brilliant minds never grasp: that true intelligence is not about displaying knowledge like a peacock's plumage, but about knowing exactly when to speak, and when to stand silent, when to teach and when to learn, when to step forward and when to guard the door. And sometimes, the greatest service one can perform is simply to remind others that excellence comes in many forms. Wisdom wears many uniforms, and the person standing quietly in the corner might just be the most remarkable person in the room.